Hello, and welcome to this 10-minute talk where we're going to be exploring the recent SRA warning notice on mergers, acquisitions, and sales of law firms. I'm Corinne Staves. I'm a partner here at CM Murray LLP, and I'm joined by two of my partners, Andrew Pavlovic and Zulon Begum. Andrew, I wonder if you could just start by sort of explaining what this is all about, please.
Yeah, so the background to this is that there's been a couple of fairly high-profile collapses of law firms in the last year or so. The first is Axiom Ince, and this was two struggling firms, Ince and Plexus, who were acquired by a much smaller firm, Axiom DWFM. And on the face of it, these acquisitions seem to be quite good things in that the acquiring firm is taking over all the clients and all the employees from the old firms. So no clients left behind, no employees left out of work, etc. Unfortunately, it appears that the acquisitions of those firms was actually funded through misappropriation of client monies. And it's believed to be around £64 million shortfall in Axiom Ince's client account, which has led to an SRA intervention, firstly into three individuals within that firm, and then secondly, the firm itself. Now, there's huge potential repercussions for the SRA and for the industry as a whole arising from that, including potential increases to practicing certificate fees and contribution fund contributions for firms and individuals. And then the second case was the collapse of the SSB group. Now, this was a firm that rapidly expanded in around 2021 to take on bulk litigation work, and it collapsed recently, went into administration with over £48 million owed to creditors. And the SRA's oversight of those two matters is in itself being subject to a review by the Legal Services Board, and the Legal Services Board's report is expected sometime after the election. So that's the sort of context for this warning notice, some fairly high-profile matters that have gone wrong. Although the warning notice does say that around 100 law firm mergers take place every year, and in most cases there's perfectly good and valid reasons for those mergers, and no issues arise from them.
I think that's a really good point, isn't it? That it does encourage law firm mergers where it's encouraging healthy competition and where that's a useful development for the profession as a whole. And I think that's probably the wider context for law firm mergers that we encounter, isn't it?
Absolutely, yeah. So you know, there are some points here that will be wider implications for all mergers that firms need to be aware of. So the facts that have led to it are hopefully quite extreme, and we won't see them too often. But it's about pulling out from this some things that are of more general implication and more general importance for all firms considering mergers.
I think one of the things that I found really interesting about the warning notice was obviously talking about the context. I think with some of the elements that it pulled out for us. Obviously, we already knew that the SRA felt very strongly about client confidentiality in merger situations, which obviously in practice is a big issue when you're thinking about perhaps sharing information to be able to do things like check conflicts. And we've found that quite challenging. I think there's some quite useful commentary here on what to do in the context of archives, closed files that you're holding as a firm until they can be destroyed in accordance with the file destruction policy. I think it's commentary on will banks. Obviously, it's drawn out the point that you can't just sell will banks like sort of bulk assets. They're very focused on client consent, which is really important. And again, that flows from existing regulatory obligations. There's nothing really new in this warning notice. It's more of a reminder on those points. But I think it is quite useful. And I think to me, there was a hint of pragmatism in terms of understanding that in certain circumstances, client consent simply can't be achieved. Now, they're right to point out that firms have got to try, and in well-managed processes, time is built into the timetable to do that. But I think that sort of pragmatic note, I think, will be welcomed by firms that are just trying to, achieve an effective merger that achieves sort of strategic growth for the firms and actually puts clients in a better position.
And I actually think that on a practical level, most mergers and people looking at doing mergers will already be complying with most of these recommendations and requirements anyway, because as you've already mentioned, Corinne, most of these obligations are already there in the SRA handbook. What it will do on a practical level actually is maybe focus minds on those people who maybe looking at a distress sale or an acquisition of a distressed company or firm, and making sure, I guess, having a real focus on doing the due diligence on those kind of distressed firms. And if you are a distressed firm yourself, making sure that you're doing reverse due diligence on the potential acquirer. And that can be quite difficult, actually, if you're in that situation, because your kind of key aim is trying to find a home for the business, so that it doesn't go into intervention and you don't end up with potential liabilities of an insolvent firm. And this warning notice may actually make finding an acquirer or acquiring such an asset much harder than it currently is. And it may also make it a bit harder on administrators, actually, who are trying to sell law firm businesses to make as much money for their creditors as they can. If they're trying to do that in the context of a warning notice, which implies that actually the solicitor managers of those firms in administration have particular duties and potential liabilities around having not done sufficient due diligence, for example, on an acquirer, then that does make it harder for those firms and intervention more likely. And I don't know what you think about that, Andrew.
It's an interesting aspect of the warning notice. It talks about potential action against both the acquiring firm, where it takes on a new firm or a new practice without having sufficient resources to be able to deal with matters, but also, as you say, potentially the distressed firm looking for a home that transfers or is acquired by a firm that doesn't have the competence or the capability to deal with their clients' matters and to protect their clients' interests. The role of the solicitor manager in a distressed firm is obviously important, and I think if a firm does have a solicitor manager on the scene, you would like to think that they would be able to rely on their judgment, although it does put, I suppose, an increased burden on the solicitor manager in that case. But certainly, this warning notice suggests that the SRA could take action against, someone who's looking for an escape route, finds a partner, and who doesn't have the resources, the capabilities, the systems, and the processes to deal with their matters, but is just there and they're willing to take anyone effectively. They could be on the hook for disciplinary action on the basis of this warning notice. And the other potential aspect that's mentioned is intervention costs. So if the new firm is then subject to an intervention, the SRA has statutory powers to recover the intervention cost from the entity, but also from any individuals whose conduct contributed to or caused the intervention. So there could be a route for the SRA to try and claw back costs from people that were involved in this process, didn't do the due diligence, and exposed their clients to either poor service or, obviously we've seen in this more recent case, just misappropriation of their monies, which, as I said, will hopefully be a lot rarer. But there are risks here that the warning notice clearly sets out.
I think those firms in administration will need to kind of look more carefully at those potential acquirers. The other thing on a practical level is often we see kind of smaller firms with partners who are approaching retirement, and without a viable succession plan behind them to hand over the business to anyone, are often in those kind of distressed situations where they need to find an acquirer for the business before they retire. Otherwise, those firms would end up in intervention, insolvency, or if they're not able to afford to pay for runoff cover. And for those types of firms, this again is a huge reminder that actually they need to think about succession plan way ahead, and not leave it right to the last minute, because the costs of runoff cover can be immense in some cases, and if you haven't done your planning way in advance, then you may not be able to find an acquirer that would effectively pass the smell test under this warning notice.
I think that's a really good point, Zulon, and I think that a lot of the firms you're talking about wouldn't consider themselves to be in a distressed scenario because the business has been robust. But what those businesses is often forgotten about is what happens when that retirement happens. What happens if one or two partners sort of step back, if the firm is wholly reliant on a number of partners that, as you say, are approaching retirement, then the financial kind of stability of the firm could be very quickly undermined. And of course, this warning notice does make sure that firms are aware that there's an obligation to notify those sorts of circumstances sooner rather than later to the SRA. So firms can be in no doubt about that. I think that that's a really good reminder on sort of prevention rather than cure, and making sure that you plan in advance so that these sorts of issues can be avoided. And I think another couple of practical points, we've talked about having a proper timetable. We've talked about making sure that proper due diligence happens. The warning notice reminds us that you need a good period to be able to notify clients and to seek their consent to make alternative arrangements for clients if they don't want to be part of that move, to make sure it's suitable for them. Take time to really track down clients that have sort of fallen off your radar a little bit. For example, if firms do estate planning and have wills in wills banks. I also think there's some other steps we can take. For example, having good client lists. It's surprising how many firms don't have good client lists for which a matter partner is responsible, and this can often happen where partners have left, and there you've got sort of some clients for whom nobody is really responsible, and they might have sort of archive files associated with them. That can be quite problematic because there isn't that knowledge there. I think that archiving and destroying files when you can and appropriately helps manage these issues on a merger, but also keeps your storage costs down, because that can actually be a big barrier from a practical perspective, from a commercial perspective on a merger. And one thing that Zulon and I often talk to clients about is thinking about having provisions in your terms of engagement to preempt these sorts of situations, to see if you can get to a situation where you feel you do have informed consent from clients to disclose information in a limited and appropriate way to facilitate these procedures, but in a way that clients would expect and have pre-agreed, if you like. Obviously, it can be case specific, but I think there is a way through for firms to manage these risks in a way that's compliant with those regulatory obligations. Thank you very much for joining us today for this short talk on this really key warning notice. If you'd like to discuss any of the issues that we've raised or get in touch with us about mergers generally, please feel free to reach out to us. Our contact details can be found on our website. Thanks very much.